Right, welcome back. A little bit later on today, from about 5 p.m. to 6 p.m., Deputy President William Ruto and former radio journalist Joshua Rabusang will know their fate. The ICC judges are set to rule on whether the two have a case to answer or not. We want to discuss that and unpackage what we expect to happen and the implications of the same. And to help us do that, we have Njenga Mwangi, who is a lawyer and he's licensed to practice at the ICC. He's joining me, taking Jao for that conversation today. And if you have any questions, comments, views, and suggestions, we invite them. The SMS number is 22422. That number again, 22422. And on Twitter, the hashtag to use, as always, is Power Breakfast. Mutegi?
Thank you, Saburu. But before we go on, I'd like to let the viewer know that we had invited two other lawyers to be in this discussion, but they have not shown up. Anyway, we'll go on. Mr. Njenga Mwangi, maybe you should tell us your relationship with the ICC and why you want to discuss the matter.
Thank you, Mutegi. To begin with, I'll just say that the events that took place in Kenya during the period of December 2007 to February 2008 are matters that troubled all of us. And I did represent the victims of the post-election violence in the Waki Commission, and initially did represent them also at the ICC. But when the court determined that they wanted a common legal representative, they chose one, Suleta Chana. And thereafter, when Suleta Chana did 1 year, she got out, and in this particular case, they put in a Kenyan lawyer called Winfred Dirito. The interest with the ICC is that all of us do know the atrocities that afflicted the country, African nation, and the world at large since Second World War. And that's why the United Nations, in its wisdom, decided to create a permanent court that will try those who bear the greatest responsibilities in atrocities that afflict mankind. That's including genocide, war crimes, and crimes against humanity. Before the ICC came into being in 2002, previously we had ad hoc courts. So we had, in 1993, they formed the International Criminal Tribunal for Yugoslavia. In 1994, they formed the International Criminal Tribunal for Rwanda. This was specifically created by the Security Council of the United Nations to try those who bore the greatest responsibilities in the atrocities in the former Yugoslavia and the atrocities in Rwanda. In 2002, after garnering enough signatories to the treaty, to the Rome Treaty, the International Criminal Court came into being. So what happened in 2007-2008 in Kenya, the case was, the International Criminal Court assumed jurisdiction over that particular case. There are three ways in which the court can assume jurisdiction over atrocities committed in the international space. One is when a country who suffers atrocities including genocide, crimes against humanity, or war crimes invites the International Criminal Court prosecutor to investigate atrocities being committed in its territory. This usually will only happen in situations where the government in power is actually not in control in all the parts of the country. So in the case of Uganda, when the atrocities that were committed by Joseph Kony in northern Uganda, the government in Kampala was, literally speaking, not in control of northern Uganda. So the government of Uganda invited the prosecutor to come and investigate those crimes. The same thing happened in DRC Congo. It also happened in Central African Republic. But we have situations where the Security Council of the United Nations, having gotten knowledge of atrocities being committed in other places, instruct the prosecutor to go and investigate. And that is basically that's what happened in the situation in Sudan. the former Sudan as a whole. The last one is where the prosecutor, receiving information from other people, other sources, be they international NGOs or civil society, and getting convinced that atrocities or crimes against humanity have been committed in a certain territory, goes to the pre-trial chamber of the ICC and seeks permission first to go and investigate. After he investigates, he goes back to the same chamber, pre-trial chamber, with the evidence he has. If the judges of the pre-trial chamber are satisfied that the atrocities did occur and they need investigation, and there is enough evidence that that has been done, then the ICC looks at the evidence and determines, yes, a case has been made that these atrocities have taken place. So it constitutes itself and allows the prosecutor to bring in the names of the people he thinks bears the greatest responsibility. Then two things that can happen is that either the court can issue warrants of arrest or summons. In the Kenyan cases, two cases, the court found it fit to issue summonses. So we had case 1 and case 2. The case 1 is the one that involved the deputy president, and then he was a minister in the coalition government, and the current president, who was then deputy prime minister. After going through the legals of the pre-trial, the court then makes a determination as to whether this case should be confirmed and put forward to the trial chamber so that evidence can now be adduced against the defendants. We saw that in the case of the former prime minister, now president, there was already both cases were confirmed, but against a number, not all the accused persons, not all, against all the defendants, but against some. So in the case of the president, they confirmed the case against the president and Mr. Muthaura, but they found that there was not enough sufficient evidence to confirm the case against January. In the second case against the deputy president, they found that there was insufficient evidence to put the deputy president and Joshua Rapsang for trial, but they dismissed the case against Henry Kosgei. So, but with time, the case against the president collapsed. The case against deputy president went on, but before he has been put to his defense, his lawyers determined that they wanted to bring in an application for the court to make a finding that there is no case to answer. That is, to dismiss the case at that stage before the defendants have been called upon to adduce any evidence. That is at the stage where we are at now. But
before the ruling is made today,
yes,
about whether there is a case to answer, there are certain other Kenyans who have been mentioned adversely and who are wanted at the Hague. In the event that there is no case to answer in the case against William Ruto and Joshua Rapsang, what happens to those other people now mentioned adversely and wanted there, like the journalists?
Yes. So far there is, I think there is the case against Balaza,
yes, and
the case against one lawyer.
Yeah.
And these have been brought under Article 70 of the Rome Statute. And those are cases or crimes against the administration of justice. Simply saying that if you interfere with the investigations, if you interfere with witnesses, or if you destroy evidence, those are crimes against the administration of justice. Those cases can go on irrespective of whether the main case is going on, because cases can collapse like did the case of the president. But if anybody was to be found to have interfered with the administration of justice, his case can still go on under Article 70. because it's a totally different purview of the law. It's interference with the work of the court. And in this case, when I'm talking about the court, I'm talking about the office of the prosecutor and the office of the court itself, the registry and the presidency of the ICC.
As we are waiting for the judges to make this ruling, the prosecutor did file recently an application about animating some other evidence which is not the recanted, or some evidence that it was not even frivolous, some kind of, I don't know the laws you use it. But she has made an application to use some certain evidence.
Let me put it this way, that in history, or in the history of the criminal justice system, there are certain presumptions that are made. One of them is that the accused or the defendant is assumed innocent until found guilty. The other one is that all evidence does not become evidence until it is tested through cross-examination. So, and this is where you'll find that the prosecutor wanting to bring in recanted evidence, or evidence where it's only statements, where the witness cannot be cross-examined. It's never been acceptable anywhere in the world. It is the first. It's only in the ICC where there is such provision. But that provision is also very straightforward. But Bensouda has tried to bend it, because evidence can be called without calling the witness, where there are statements or affidavits. But under that specific rule, the one they call amended Rule 68, is very specific that that evidence, for it to be admissible, it must not touch on the conduct of the accused person. All the acts purported to have been perpetrated by the accused person. So, for example, I will say, we know, for example, the people died, and Working Commission proved as much. So that 1,300 people died, or 1,130 people died, that is a fact. One witness can come and adduce that fact. You don't need to call 10 others. Or, for example, there was the house in Naivasha that was burnt down and people died. One witness, live witness, can come and adduce that. But you can get statements of 10 other people who will show that the church died. I mean, the house was burnt down. But it should never bring in the conduct of the accused person, because the conduct of the actions of the accused person can only be proved if a live witness is brought forward and he is subjected to cross-examination. So in this case, after Sang and Deputy President's lawyers determined they wanted to bring an application of no case to answer. This even in the local jurisdiction it happens. As the prosecution closes its case, lawyers do make a submission as to whether there is a case to answer or not. Here in this case we call it prima facie case, because there is no point of wasting the court's time in asking the defendant to bring in evidence when the evidence that has already been adduced by the prosecutor is not sufficient to even show that, to connect the accused persons with the crimes. When I read through the application by the Deputy President and Sang's lawyers, they're very strong, because there are certain contradictions that have come out during this period, including her being allowed to call in witnesses who had recanted their evidences. You see, there's so much contradictions that there is very little that can connect the accused person to the crimes that are purported to have been committed. My take on this is, first, is that the then prosecutor of the ICC, Moleno Ocampo, he did very little investigations here. And the problem with most Kenyans or most lawyers who practice in that court and this has been discussed in many forums where lawyers practicing at the ICC contribute, is that you can't force somebody to give evidence. If a person who was a witness or proposed witness recants his evidence, you cannot force him to give a different story. If he did give evidence under oath and he lied, then you will be going to crimes committed under Article 70 of obstruction to justice or administration, crimes against the administration of justice. What we've noted in this particular case is that none of those witnesses who recanted their evidence have been charged with any offense under Article 70.
Why is that so?
I again think I think it's lack of due diligence by the office of the prosecutor. But again, I'll put it this way: the court, the ICC, has tried people from, literally speaking, banana states. The case against Bemba and against the others in DRC Congo and Central African Republic. Those are territories that are really war territories. The Kenyan case was the first case where the prosecutor took the initiative to ask for permission to prosecute, to investigate and then to prosecute. My take is that the judges had almost literally taken the view that Kenya was the equivalent of DRC Congo or Central African Republic, which was totally different. We had functional courts, we had functional governments. When Ocampo came to investigate here, he was provided with government resources for his own protection. In places like northern Uganda, he had to go with his own armed guards. In places like DRC Congo, he had to go with his own armed guards. So the mindset of the ICC was totally or diagonally opposed to what literally happens, what's happening in this country. We did go through a bad period. That's true. Everybody is aware of that, and we all get pained about that. But Kenya still was never a banana state.
I don't know whether what you mean by not being a banana state, because why is it is not possible? 1,000 people are killed. Many were displaced. Why did the prosecutor not get witnesses? And why those who are recanting? Why is it?
You see, the debate about how the prosecutor did his work, it was very shoddy. Then again, a lot of people are unhappy because the ICC seems to target African nations. The atrocities that have been committed by Israel, the state of Israel, in Gaza and the West Bank, are not comparable to what happened here. The atrocities that have been committed in Syria, for example, are not comparable. So the resources that have been used to prosecute the Kenyan case has no relation with what happened compared to what has happened in Syria. In Syria, so far, over 100,000 people have died. Millions have fled that country. Compare it with Kenya. Even one life is so precious, we should never allow it to happen. It's 1,000 compared to over 100,000. 750,000 displaced compared to several millions. The double standard of that court is what has brought the disconnect with the African nations.
But isn't it the case that maybe one can argue that, were it not the fact that elections were held in 2013 and the enemies became friends? Because during that 2007 and 2008, William Ruto and Uhuru Kenyatta were in different political camps. That's why they are different separate cases. Where they teamed up. became president and deputy president. If the situation was not as such, don't you imagine that maybe the case the case will continue with those witnesses recanting, not doing so, because you don't want to go and testify against your president or your deputy president.
First of all, that that premise is not completely true. It's true to a certain extent, because this court has a lot of resources for the protection of witnesses. Yeah. And the protection of witness doesn't mean the individual person who testifies, but includes his family and all those around him who can be vulnerable or who can be targeted by the accused person. So that court we cannot say that the accused persons did not or refused to testify because they didn't want to testify against the president. There's some truth in that too, that nobody wants to testify against the powers that be. But who, and this is a question that a lot of people have asked Mutegi, and I come from Molo, where violence started much earlier before it happened in the North Rift. And the question people ask is very simple. If this court targets the people who bore the greatest responsibility, both the president and the deputy were not vying for any power in the 2007 elections. There was President Kibaki and there was former Prime Minister Raila Odinga who were vying for those seats. If violence happened because of search for political power, then the two people who should have been in that court would have been the Prime Minister, former Prime Minister, and the President. That did not happen. Ocampo made a great mistake to begin with when he said that he will target people in PNU and people in ODM then. So he took 3 from ODM and 3 from the PNU coalition, because strictly speaking, Uhuru was not a member of PNU. President Uhuru was the chairman of KANU then. So he took 3 from the president's side and 3 from the prime minister's side. In the history of this court, which so far has only convicted 2 people since 2002, remembering that a lot of people believe or think that Slobodan Milosevic and Kalajic were being tried by the ICC. Those were being tried by the ICTY, the International Criminal Court for Yugoslavia, but it sits at The Hague. The same thing with former president of Sierra Leone, Liberia. He was being tried by the Special Court for Sierra Leone, which was sitting in The Hague. So this court, the history is very short of this court, but so far this is the only situation where out of 6 people who are charged with crimes, only 2 are left standing before it has gone for the whole trial. For this court, my thinking that it's improbable that it will confirm this particular case to go for the defense hearing, unless it has brought down the threshold of evidence to such an extent that it will bring an international outcry.
Would it be arguable that one of the considerations of the court is that the threat by African countries to pull out, that if they confirm that there is consequence and proceed with that hearing of William Ruto and Arab Sang, therefore the African countries will pull out and the court may be rendered irrelevant?
The African component of the ICC forms more than 30% of the membership of the Rome Statute, and that's a very big component. When you take it into account that countries like the United States of America Russia, China are not members of the ICC. So that would be, so that threat is real. I'm thinking that my legal mind tells me the judges will not be very worried about that. But there could be certain partners of that court who will be very worried if the African component got out. But going strictly by the evidence that so far have been adduced, I will tell you, for example, how shoddy the investigation was. Whilst at the ICC one time, I heard there was a witness who came and said about Deputy President's presence in 64 Stadium in Eldoret with the former Prime Minister, where he agitated about the uprooting of the Badoa, meaning the Kikuyus. But when challenged during cross-examination, the display of television caption shows that that rally took place at Huruma grounds in Eldoret, and no such utterances were made. If a prosecutor would present before the court such a witness, it tells you one thing, is that the prosecutor never did his homework. Because if he had done his homework, and he knows that on the 10th of December there was a rally, a purported rally at 64 Stadium, which must have been covered by television and radio stations. There's nothing that would have been easier than to go back and do research from those who monitor the media.
Like Stedman.
Exactly, like Stedman, yeah, who monitor the media, and who would have discovered that this witness, having given such detailed evidence about the stadium, including the podium where the two are addressing the attendees, there's nothing would have been easier than that. So that by itself tells you this prosecutor did not do his work, and that should have started worrying the judges about this. The same thing if you go back to the case against the president, where recanted evidence, where there was an affidavit of one witness saying that he was never in State House, he was never at Nairobi Club, he was never at EI. That evidence was still adduced before the judges. So that inconsistency in the evidence that have been adduced bring forth the question, should this case still go on? Should this court exercise what we call judicial economy by stopping a case that doesn't have legs, so to speak?
There is an argument which I raised to you before that
yes.
If the judges are going to rule there is no case to answer, that will be final. But the rules of the ICC say that if a final judgment is going to be made, whether guilty or not guilty, that judgment must be done in public. And this is not going to be done in public. Therefore, some people are concluding, therefore there may be a case to answer. But what we expect in the evening is that there is a case to answer, because it's not being done in public.
No, first of all, I think that somebody is, there are many different ways in which you interpret the law. And we have one we call the mischievous rule of interpreting the law. There's one we call the golden rule. And what is common? I think somebody is using the mischievous rule of interpretation, because this is an application. It's not a hearing per se. It's an application that has been made. Applications by their nature can even be dispensed by submissions without calling it any evidence, which means you can just do the application, write your submissions, the opposing side writes their submissions, the judge reads both of them, and then he comes to a decision one way or the other. If, for example, the court finds that there is no case to answer, it's very simple. Summon the accused person to appear in court so that the case is dismissed. But at this particular point, where the question is whether there is a case to answer or not, the accused person need not to be in court. The court can determine there is no, and then make a formal date when the accused person will come, and it will be dismissed in open court. Yes. So I think it's far-fetched to say that there is a case to answer because the accused person have not been summoned to personally be in open court when it's being read, because this is not a judgment, it's a decision. a decision relating to a particular application, period.
During this time, the politicians have been making utterances here in Kenya, which tended to annoy the president of the ICC. Some of them making demands about what they want and what they don't want.
I think that is.
Some of the politicians are even lawyers.
I think that's just bad manners on the part of our politicians. And literally speaking, they're not known to be very good mannered, because you can't start directing the court on what to do. If they will give directions to the ICC what to do, what would be different from them giving directions to our courts on what to do? So politicians have been known to do that, but prudence and common sense will tell you that the court will, at the end of the day, come to a conclusion, take into consideration all the evidence that have been adduced by the prosecutor and the contradictions that have been shown in the evidence that have been produced before the court. So my advice to politicians in all cases is that never comment on matters that are in court. Literally speaking, it's not because they are matters that are sub judice. Let the court determine the fate of the two depending on the evidence that has been produced. My take, there have not been sufficient evidence to put them to their defense. That's my take from, and these cases that have followed very closely. There haven't been sufficient evidence to all. No prima facie case has been established so far against either of the two.
In case the judges rule that there is no case to answer, what course of action can the prosecutor take? Is there any chance for an appeal or
yes,
going ahead?
The prosecutor.
What course of action would she take?
The prosecutor, the same thing like she did the last time when recanted evidence was. She called for recanted evidence, and the appeals chamber says that's not possible. So the same case, this application for no case to answer. Once they determine that there is no case to answer, the prosecutor can still go on appeal to the appeals chamber. But my take on that is that these cases have taken too long. A properly conducted case, literally speaking, should not be taking more than a year to prosecute, where there is proper investigation. Now, we've been in that court since 2009. Now, we are 2016, 7 years. And if there was weighty evidence that had been adduced so far, you could say it's working. 7 years, putting people's lives on hold, giving false expectations, because this court still has the obligation to manage the expectation of the victims. So the victims have actually been put in a seesaw. Sometimes they think they are going to get justice. Sometimes they find they don't get justice. You found some of those victims themselves withdrawing from participating in that court, because if they wanted to participate in 2011, because they thought maybe by 2013 they will get justice, 6 years down the line, 7 years down the line, they don't have any expectations. So this court has also failed to manage the expectations of the victims. The other thing that this court has failed is that there is a victims fund, that is contributed to by the international community. We've seen the victims fund used in Uganda, we've seen it in DRC Congo, we've seen it done in Central African Republic. None of the victims of this have ever received even psychological mentoring. There have not been psychologists who have been called to come and try to help them deal with the ordeal they went through. Why? Again, I know that there was an application that was made to the Victims Fund committee 2 years down the line, but so far nothing has come out of it.
So in the event that the court rules there is no case to answer, what recourse have the victims?
Well, the victims, so far, I do know that I represent quite a big portion of that who have filed constitutional court cases in the Kenyan courts, in the High Court, seeking compensation by the government. Their argument being that, being taxpayers, the government is obliged to give them security. If the government did not give them adequate security during that period, the losses they suffered, they should be compensated for by the government. Again, in the last year, during the State of the Nation address by the President, if I remember right, some 10 billion was set aside for historical injustices, to cater for historical injustices. Post-election violence caused some of those historical injustices. So, I do know, and after filing the cases, the Attorney General has invited us to negotiate. So, the victims have recourse to that.
But that's in the Kenyan court.
Yes, that's in the Kenyan.
What about the international court?
In the international court.
And do they have any cause?
They don't have.
Why not?
If
there is money set by the international community for them to be paid, to be compensated, like what we were talking about, psychological counseling.
Yes.
Why can't the international court, since they took over the matter from the Kenyan court, why can't they?
No, that's not the.
And in any case, the ICC they are represented here.
The victims' lawyers, common legal representative, can always make an application for the court to order some form of compensation or to the victims. Again, that's purely in the hands of the advocate who represents the victims.
Is there a possibility that will happen?
I really don't know, because I've not had any discussion with the current representative of the victims. But again, this is pressure can be brought to bear on that court that it owes it to victims, not only of Uganda, Central African Republic, and DRC, to the victims also in Kenya too. They deserve to be.
When you say you have gone to court to sue the government for compensation,
yes.
What about the settlement that has been going on? Isn't that part of the compensation? Or what is
yes, it is. Now, what I'm saying, okay.
People who are killed, or people who are who lost their relatives, or what?
People who died.
Yes.
Their relatives can seek compensation. People who are displaced, for example, you see the people. And this is something that a lot of Kenyans don't really comprehend. There are three types of victims we had. We had victims who were flushed from their own homes, who owned land, their houses were burnt. But those victims who had their own properties and they were flushed out of their houses, or the houses were burnt, they were resettled. They went back to their homes by July 2008. By July 2008, remember that Operation Rudi Nyumbani. There were victims also who were small-scale traders in areas where they were flushed and their business were destroyed. They were not landowners.
Yeah.
There were also other victims who had leased land from other people, where they grew crops and sold, but they did not own land. Those are the victims who were resettled by the government in Nyandarua, in Laikipia, and parts of Nakuru. But so if you owned land in burnt forest and your house worth 10 million was burned down, the government gave you 35,000 bob. It's not enough even to build a modern kiosk. So that person is entitled to be put in the same position he was in December 2007, and we hope to persuade the courts to make that determination. People who had several 10 great cows which were stolen or slaughtered, he can seek compensation from the government. So that is the cases but they are in court also, and we are not. I'm not seeking to discuss this here, but we'll adduce the evidence to show that the government did not protect its people in the hour of need.
A number of people were raped, a number of women were raped at that time, and I think the police set up an investigating group to investigate rape cases, and I think it came to naught. How are those now to be dealt with?
I also know that there is a case about the victims of rape in court today, especially in what happened in Madare and Kibera.
Yeah.
There is a case for compensation. I can't remember which particular lawyer is dealing with it. But you see, the longer a case takes, the more difficult it becomes. Evidence disappear, get destroyed, memories fade. So, for example, there are people who have been charged with what happened in Kenya in the 2007-2008 post-election violence. But either because of poor evidence gathering by the police, a lot of them were acquitted. But some have been convicted. I don't have the statistics with me, but it's in public. If you Google it, you can find how many post-election victims, accused persons were convicted and how many were acquitted. That, and I think even the Office of the Attorney General had gathered those statistics.
Okay, in the event that the court rules there is a case to answer, and what do you expect to happen now?
Well, if they rule there's a case to answer, because there's only two ways. If there is no case to answer this, then they will summon the two defendants to present their case, and then at the end of
which means what? What are they supposed to do?
What it means is that they will bring their evidence, they will call their own witnesses whose particular aim will be to contradict the evidence that has been adduced by the prosecutor. So when the court now weighs the evidence of the prosecutor and the defense witnesses' evidence, then it will come to a conclusion as to whether they are guilty or not. Remembering that it's universally criminal cases, proof must be beyond reasonable doubt. So as long what the defense would be doing now is to create doubt, because if it's not beyond reasonable doubt, then the benefit of the doubt is given to the accused person, and therefore they must be acquitted. So the confirming that there is a case to answer does not mean that there will be a judgment to convict the accused person. Yes.
What about in terms of politics? I know you're not a politician. If this year is going to be a year for politics and the elections of next year,
let me say this.
If the case continues there, what does that mean in terms of politics?
Mutagi, let me say that first of all, the United Nations and its Security Council, one of the principles that formed the creation of the Security Council is for ensuring that there is international peace and security. And anything that can bring insecurity in a country or in a region, we should be very, very worried about it. And every time this case comes up, there are some tensions, especially in the Rift Valley. There are tensions, and we cannot wish them away. What it will do politically, it means that this case we are in April. This case could drag to next year, which is an election year.
Yeah.
Is it in the interest of this country or the region for this case to still be going on next year?
It's for the interest of the victims.
Most of those victims are still in that Rift Valley. If I don't know why all these research companies that tell us about politics have not come with a research.
You mean the pollsters?
The pollsters, yes, a research as to what do those victims really want. Are they feeling more secure with the case going on or with the case terminated? My guess is that they will feel more secure if that case is terminated. I literally, personally, the clamor for withdrawal from that court, I don't believe in it. I don't believe in it. The idea of the International Criminal Court is a noble idea. All that needs to be done is to group all nations to be members, so that we don't have some who feel they can cause atrocities and not get punished, whereas the weaker brothers, once they cause atrocities, can get punished.
But you can see, we don't seem to be learning from those cases of ICC. If you see what is happening here now, people are still shouting hate in political meetings, hate speech. What is happening in Rwanda and Burundi, people have been killed because of politics. Do you think people, it looks like
people are being killed in Syria. But you've seen Russians bombing residential
and even hospitals
in Syria. Why is not the prosecutor investigating those atrocities being committed by Russia or being committed by Syria? There is a disconnect here. And that is why I said the idea of the creation of the International Criminal Court is very noble, but we must rope in all the nations. Anybody who is a member of the International United Nations ought to sign that treaty. A treaty that is signed mostly by the weak and targets only the weak. At the end of the day, it will not succeed. At the end of the day, it will not succeed.
But in our case, we took it to ourselves. We said we decided not to form a local tribunal.
Yeah,
and we said let's go to the Hague.
Yes, it is not. Again, it was a political decision by our politicians who thought that what they were doing was the right thing. Yeah. Remember, I was here with you and Jimmy. We were discussing about the formation of a local tribunal. They refused to reason to the wisdom of forming a local tribunal. 6 years down the line, it costs enormous resources to be put, misdirected the energy that should be used in creating wealth or in making our country better into defending a case that could have been handled locally.
At that time, the Kenyans, many Kenyans did not have faith in the judicial system. The judicial has since undergone some changes.
Yes, well, even today you'll still hear noises about it. And I think the rejection of our judicial system then was not in good faith. Because if you remember, those who lost elections in that particular one, they filed petitions in court, and the courts found in their favor or against them across the two divide, the PNU and so I think the clamor that we don't have faith in our judiciary was not genuine, was not in good faith. It was a reason to reject the elections, and some people benefited because now we got the Serikali of Nsumukati.
So anyway, today you expect that the judges were going to rule there's no case?
Yes.
So what happens tomorrow?
Well, if there's no case to answer, the next thing I think is that there will be somebody, they will have what they call it, a conference in which they will determine the dates when the accused person should be called in to formally dismiss the case.
Thank you very much, Mr. Jenga.
Thank you, Mr. Mutegi.
And we hope the best for our country.
Asante sana.